Good afternoon. I'd like to welcome you to the 2019 Freedom of Information Act training session. I'm Deputy Attorney General Daniel Mulveny, and I'm pleased to be here. Some disclaimers for this presentation. The legislature has specifically provided the presentation is not to be construed as legal advice. And the information that we are today going to present, it follows is that we try to summarize the law. We can't address every single situation, and we can't address all the various fact-specific situations that come up. And if you have a question about today's presentation, I ask that you hold that until we have a formal Q&A session at the end. If you have a question about FOIA, we ask that you contact your legal counsel. We ask also that you review the Department of Justice's policy manual, which was updated today, November 14, 2019. The legislature has given a declaration for the FOIA statute. The FOIA statute was in Delaware, started in 1977. It followed the general federal FOIA statute that reached its sort of current form about that time, sort of post-Watergate. The purposes of FOIA is to promote governmental transparency and accountability. It's to inform the citizens, and it's to allow citizens to observe the performance of its government bodies in public and monitor the performance of public officials. The Department of Justice maintains and publishes a FOIA manual. Just as I mentioned earlier, it was published this morning on November 14, 2019, and it's intended to be an easy reference for FOIA for purposes of FOIA coordinators in the state. And we update that every 2 years. And as part of the Department of Justice's mission under FOIA, we have a annual training, which is today, and it's open to the public. And we provide guidance for FOIA coordinators and others involved in responding to FOIA requests. During this training, we discuss the FOIA statute, the cases, some Attorney General opinions, and interpretations of the FOIA statute. What today's presentation will cover are the FOIA coordinator's duties and responsibilities, the deadlines associated with FOIA requests, fees that may be charged by public body responding to FOIA requests. We will address some FOIA petitions that are to the Attorney General, and we'll also have a panel discussion with FOIA coordinators on their best practices. There'll be a brief discussion on judicial and Attorney General opinions for FOIA over the past 2 years, and then we will end with a question and answer session. At this time, I would like to hand over to Kim Siegel to have a discussion on FOIA coordinators.
Most of you are here because you are a FOIA coordinator or because your FOIA coordinator told you about this session. Every public body is required to have a FOIA coordinator. You have to tell the Delaware Department of Justice who the FOIA coordinator is. You also have to tell the public by identifying the FOIA coordinator on the website. Last year, somebody here recommended that we create a list of FOIA coordinators and email addresses so the FOIA coordinators could converse among themselves. And in the process of coming up with that list, we discovered there were a lot of people who had not updated their information with the Delaware Department of Justice, and even more who did not have the information on their website. So if you found out about this training from me, assume that you are the FOIA coordinator, we have your information. If you did not hear about it from me and you know you're your public body's FOIA coordinator, if you can please send that information to opengovernment@delaware.gov. We'll get our list updated. If anyone would like to see a copy of the list we do have, I did bring a few of those. Also, you may want to check your websites to make sure that the FOIA coordinator is clearly identified on there. What does the FOIA coordinator actually get to do? We're responsible for coordinating and processing FOIA requests. So, finding out what people want, getting their written requests, figuring out if the public body has them, helping the person figure out maybe what they're looking for, if they know they're looking for a certain kind of information but aren't sure what they're asking for. It's the FOIA coordinator's job to try to help them locate it or to explain why they can't have a particular record if it falls under one of the exemptions that we'll be talking about later, for example. And you also get to keep the FOIA log. The FOIA log, and there's a sample of this in the manual that's on the website, and I can't recall if I sent it with yesterday's email. You have to have all of this information that's listed here. I'm not going to go through each piece of the information. I want to add a tip that someone mentioned during the panel last year of what would make it really easy is taking a look at it every day and just recording whatever activities happen related to FOIA on that day. Because I don't know about you all, we get a lot and it piles up when you have to record every piece of correspondence that we get. And now on to the question of FOIA policies. So every public body should have a FOIA policy, and Deputy Attorney General Jaros is going to go over those in a little bit more detail. But these next couple of slides cover what the statute absolutely requires and what's up to the public body itself. So it'll govern how you receive FOIA requests. So making a phone call, for example, is probably not a sufficient FOIA request. You need something in writing or the person to be standing there. It outlines the roles and duties that the previous slide went over. It explains how to respond to general FOIA requests for regular documents, for files, requests for emails, because that's a little more technically complicated or technologically complicated, and how to handle a request when you're not the public body that is actually in custody of the records. It also governs how to conduct the legal review to identify whether the records that are being requested are something that can or can't be turned over, or you have the option not to turn over. It explains how what kind of access you have to provide. You don't always have to provide copies, particularly if you have something that's extremely long. Requesters may want to just come in and take a look at the documents rather than paying copying fees. And speaking of fees, the statute also lays out the default fees that are applicable to searching and copying and producing records. And moving on now, I'm going to turn this over to Deputy Attorney General Carla Jaros for a more detailed look at how we respond.
Thank you, Kim. Good morning, everyone. As Kim and Dan have both said, we're here because FOIA is this purpose is government transparency. So as Kim discussed, the role of FOIA coordinator is to really assist the public in locating the documents that they're looking for. So very basic overview of what to do with responding to requests. Once you get a FOIA request in, and that can come in all kinds of different formats, you want to determine what's being asked. And you can go back to the requester to find out what on earth they're looking for. If you don't have the document but know who does, you also want to be responsible for directing them to the right location or sending the FOIA request on to that agency. Then collecting up the requested documents or determining whether you are going to have a partial or full denial of the request. And finally, once you have found the documents you are thinking are responsive, you want to review them for any that you would like to redact or remove based on what is non-public. So the list of non-public records is found in Title 29, Delaware Code 1002L. And finally, you're going to send the responsive documents to the requester, ideally in the format that they've asked for. So first we're going to talk about FOIA policy. So as Kim stated, the statute requires public bodies to adopt a FOIA policy, and this policy cannot contradict with the statute itself. But know that because, again, the purpose of FOIA is governmental transparency, if a requester does not use the public body's format, their request can't be denied on that basis alone. The most important thing to consider with your FOIA policy is to maintain consistency. So if you have provisions within it that allow for the waiver of any or all administrative fees, you want to make sure that that's applied equally to the same class, the particular classes of person. So, for example, you don't want to apply it unequally to an individual. You want to make sure that all the press has one policy, or nonprofit agencies, or anything like that. Some important deadlines in regards to FOIA. So your initial response, the public body's initial response to a FOIA request, is required as soon as possible, but no later than 15 business days from the receipt of the request. Your response must indicate one of the following: that you're going to provide the records, and then you provide them. 2, that the FOIA request is being denied, and you want to include the basis for denial. This does not require you provide an actual cite to the FOIA statute, although that is useful if down the road you're met with a petition to the Attorney General's office. Number 3, if you need additional time, and we're going to talk about when you can ask for additional time. There are only specific reasons in which you can ask for it. And if you're going to ask for it, you need to provide a good faith estimate of how much additional time you need. And finally, if there will be fees. There's been a number of AG petitions and opinions dealing lately with the good faith estimate of fees lately. And we're going to talk about that a little bit more in our FOIA coordinator panel discussion. The AG's office doesn't want to get into giving you a specific format because public bodies are so different. A good faith estimate of fees is going to look different depending on the parameters of the organization. Additional time. So if your FOIA response is, I need additional time, you can only ask for it in 3 different situations. 1, because the records you're looking for are voluminous. They're huge. 2, the record request, you need legal advice in connection with the request. 3, the records are stored somewhere where you are archived, or they're in storage, or it's going to be difficult to get to them. You need to provide a good faith estimate of how much additional time is needed. So soon, in a couple of months, that's not enough. We want to make sure that you pin down your estimate with actual knowledge. So if you have received a request for emails, FOIA is going to require you as a public body to attempt to fulfill that request using your own staff and from your own records. So you want to, you don't want to immediately go to that outside source, that DTI, that third-party technology provider, to help you with an email records request. You want to start in-house before moving on. But if you have tried in-house and you just can't fulfill the request, it is at that point that you can go to the outside third-party service provider, and but be forewarned, companies like DTI may charge an hourly rate. What are the steps you need to take to do that in-house search? First, you want to identify any employees that would have the type of access to the emails that you are looking for. And then request that employee search for the responsive documents. Oftentimes you could provide search terms for the employee. Perhaps you can go back to the requester and ask for specific search terms. And it's, if you cannot find the employee or the employee cannot conduct the search, it's at that point you're going to go to that third-party provider. If you've done a search, you've found responsive records, but you are going to deny the request for a particular reason, you need to include in your denial why. So, however, there is no obligation if you have provided a partial response or redacted some of the records that you're providing to keep a log or an index of what you have redacted. There's no obligation to provide that to the Attorney General's office or a requester. And now I'm going to turn over this presentation to Deputy Attorney General Joe Hanlon to talk more about fees involved.
Thank you. Good afternoon. Fees. This all stems from Section 10,003M. So my short presentation will deal with one subsection of one section of FOIA, and that's subsection M, talking about fees. Now, fees are can be charged. Obviously, FOIA is not designed to be a profit machine for the government. It's not designed to help balance the budget, but for repeated FOIA requests or for voluminous FOIA requests, fees may be assessed, as most of you know and are aware. And we'll go over some of the rules and some of the decisions dealing with the sections on fees. There are limits on what can be charged. Fees should be minimized. And that's something to keep in mind, that the government should always look to keeping the fees minimized to the greatest extent possible. Look for ways to make things cheaper for people requesting documents under FOIA, and work with them to narrow their request if the fees seem like they're going to be extraordinary. Bodies may adopt an alternate fee schedule, and that's an alternate fee schedule than what we're going to go over in the next slide, and we'll get to that in a moment, and that is something that is an option. So as most of you probably know, the standardized fees for pages are the first 20 pages are free. If it's a short FOIA request, don't charge. I would recommend if it's around 20 pages or that number, don't assess a charge, but you can't do it for the first 20 pages. After that, you may charge 10 cents per page, and there are increased costs for larger productions that I won't read off. But again, going back to that, these are the fees that are in the statute. The statute actually does permit agencies and city and county government and other governments that are covered by FOIA to adopt an alternative fee schedule, which is interesting. It has to be done either through the Delaware Code, and that would be for state agencies, or for municipalities, it would have to be done by a city code or a county code change. There was one decision from 2013 where I believe it was the city of Wilmington had a rule or some kind of regulation that wasn't formally adopted into their code, where they attempted to alter the fee schedule, and the Attorney General decided that was not permissible. It has to be codified. And then the other interesting thing is the FOIA statute does seem to contemplate allowing government to actually charge more. And I could only come across one decision where someone attempted to do that, and it was only like 25 cents per page, and it was upheld. So that is an option that I don't believe is exercised at all, if not frequently. The statute suggests that administrative fees are required, but allows agencies to adopt policies to waive those fees. Obviously, that's a good idea. If you're going to have a practice of waiving fees to be consistent, it should be in your FOIA policy as to when you're going to do so. And I believe Carla commented on that earlier. It's permitted for only requests that take more than at least an hour. So if it's something that can be done in under an hour, don't estimate or charge a fee for that. And again, the statute requires that public bodies try to minimize administrative fees and charge only those that are reasonably required to handle the request. It includes staff time associated with processing the request. So that means any individuals who are trying to gather documents to figure out where documents are, if they're in archives, getting the documents, retrieving them, monitoring them. Some FOIA requests, a lot of FOIA requests are easy. I want this report or this contract. You pull it out of a file or whatever. But sometimes you might get a request that's, I want all correspondence, files, communications relating to or concerning a certain topic, like cap and trade or something like that. That obviously might require a lot of staff getting together and figuring out, well, where could documents responsive to this request even exist, and going to different people. And that might take a lot of time, and that's the sort of thing that FOIA allows agencies and governmental bodies to charge a reasonable fee for, an administrative fee. It has to be billed at the quarterly hour. That's 15-minute increments, I believe is how that math works out. Fees cannot be charged for legal review. That does not mean that you can charge as long as it's not a lawyer doing the review. What that generally means, if someone's sitting down looking at the FOIA statute at all of its exceptions to the public records definition, if they're doing that to analyze whether a document is subject to an exception, not producible, that generally speaking is going to be considered a legal review regardless of who's doing it. So this gets misinterpreted. People think, well, if we don't involve lawyers, we could charge our time responding to this. That is not true. And there are a lot of opinions on that point. There is an exception, and I was only able to find one decision recently on this, where if it's a subject matter review, and I take this to mean that if a request is one of those things where it's relating to or concerning a certain topic and you're trying to figure out what items might fit that topic, that might be considered something that is a subject matter review. There was one case involving Newcastle County Police Department where a request was made for a policy manual and personnel manual, and there was a review needed to be done to determine whether the production of any part of that manual would jeopardize public safety. And the argument was that a lawyer is not really well suited to do that, and that review was upheld as permitted and could be charged the time for that review. But I would caution that anytime you're looking at documents to see if they meet an exception, it's going to be considered a legal review, so just look at that carefully. Fee waivers, again, must comply with policy and be applied consistently, which is always a good principle to live by as a governmental agency. I'm going to spend quite some time talking about microfiche now. I don't know if anyone ever uses microfiche anymore. Maybe some governmental agencies are doing that, but there's different fees for that. I was kidding. We won't talk about that. Electronic records, obviously, if you burn something to a disk, you could charge for the cost of the disk. I don't think they're too expensive anymore. So, consider waiving those, consistent with the FOIA policy of keeping costs reasonable. And third-party custodian fees. There are times when governmental agencies might not have a robust IT staff and might have to hire someone from an outside agency or buy software to do an email or text extraction. There are cases that address that on our website, and those fees have been upheld. And of course, again, they have to be reasonable. You have to go to a vendor that charges reasonable fees, not just the first one you pick, but there is support for that if your IT department cannot reasonably handle a request. Estimates. So you could provide an estimate. You're required to provide an estimate, actually, if you're going to charge a fee, to give the FOIA requester an ability to maybe modify the request, to withdraw the request. And you have to list all the charges out in the itemization. It's important to keep these consistent. So you might want to consider having a form if you don't have a form. And you don't have to, sometimes lawyers in private practice will bill every 0.1 amount of hours that they work, and with the description you don't have to do that, but you have to list who all is working on the request, maybe their title, to give some direction to the requester as to ensure you're not using the CEO of your agency or the top official to keep the cost high, and then what their hourly rate is. And there is a requirement that you use the person most capable of handling the request that makes whose hourly rate is the least in your agency. Estimates obviously have to be prepared in good faith and not designed to discourage the request. Advanced payments are permitted, and obviously if the estimate exceeds the actual cost, you're required to reimburse. That should go without saying. So just to summarize on fees, again, this is all in 10,003M in the statute. Ensure that your fee collection practice complies with the statute and any internal policy that you have, and that they're done in good faith and not designed to discourage the request. And with that, I will turn the podium over to Dory Cole, who is the DOJ Deputy Attorney General dealing with FOIA.
Thank you, and good afternoon. In this section, we're going to discuss what happens when a citizen believes a public body has violated FOIA. A citizen may believe that a public body improperly denied their request for records, or that the public body's actions at a public meeting were improper, and in that case, they can file a written petition with our office. As FOIA coordinators, it's important to be aware of this process and how it works so you can assist your public bodies in responding to a FOIA petition when one of the actions is challenged. Title 29, 10,005, Section 10,005, this is the statute giving our office the authority and the responsibility to review and decide FOIA petitions. This petition process is separate from the court remedies that a citizen may pursue. And I do just want to point out, we'll talk about this a little bit later as well, but the statute does give our office the authority to consider FOIA violations only and not other statutes. So the first step in the process is when our office receives a petition. We're going to take a look at a couple of samples. This first sample is a records request petition. And generally we look for a couple of basic elements when we receive a petition. We want to make sure it's sent to the DOJ FOIA coordinator at the open government email that's listed up there as well. We want to make sure that it describes how FOIA was violated, and it includes the evidence that's available to the petitioner to support that claim. If the petition relates to a records request, we ask that that petition include a copy of the original request, if it's available, and a copy of the public body's response so we're able to evaluate the claim thoroughly. So if we look at this sample here, the citizen requested criminal investigatory records. They stated the belief it was improper and that the denial was improper because the investigation was closed. They attached the copy of the original request and the response. They also had some additional evidence here, an email they'd received from the town, and they also included that with the petition. So this is a good example that checks all the boxes of what we're looking for. This next sample is an open meetings petition. And again, we're looking to make sure that they've described the FOIA violation and the facts surrounding it. They've attached a copy of the minutes and the agenda, so we're able to identify what meeting they're talking about. It's important to be specific about that. It also includes the allegation that they believe a major issue, a $10 million construction project, was discussed and voted upon, and the proper public notice was not provided. So these two examples are fairly basic, but we don't require a sophisticated analysis. We don't require that they're submitted by lawyers. We can receive these petitions from any citizen, and there's no requirement they cite to the statute specifically. Now, our office has recently adopted a set of procedures for the petition process. They're available on our website. And if it is the first time you're receiving a petition as a FOIA coordinator, I recommend that you start with these procedures and read through them to understand the process overall. So I'm just briefly going to walk through what the steps that are generally followed through this process. The first step, again, is the petition. We do an initial review of that petition to make sure that it's complete, that it's checked all the basic elements that are required by the procedures. And then in most situations, the next step is to send a letter to both the public body and the petitioner and asking the public body to provide a response within 6 business days. Most, if not all, public bodies have their legal counsel involved in drafting their responses, but the FOIA coordinators may also be involved, especially if it's regarding a records request. And once the public body has completed its response, we ask that it's sent to our office, and also a copy is sent to the petitioner. I would note there are times where a petition presents a fairly straightforward issue and includes all the information that's needed, and in that case, we would simply send a letter to the public body notifying them that a petition's been filed but not requesting a response at that time. Once we have all the submissions, we'd review those and issue a determination. In very rare cases, we may ask for additional information, but that's not the general practice. Once the opinion is completed, parties will all receive a copy. If it is issued as an Attorney General opinion, it'll be given a number and added to our website. And you'll see there's a link to where we store all of our and post all of our Attorney General opinions. So if you are looking for additional guidance about a FOIA issue that's given you some trouble, this is a great place to look. It has all of our opinions arranged by date, but you can also search by keyword. So it's a great resource if you are looking for more information. There are time limitations on how long a petitioner has to file a petition with our office. For all state entities, that includes boards, agencies, departments, any entity that the DOJ represents, the petitioner has 60 days to file a petition after receiving a denial of records. For all other types of petitions, and that would include all open meeting petitions and also all records denials by a non-state entity such as a city or county, that time frame is 6 months from the date of the alleged violation. Just a couple things to keep in mind. The public bodies have the burden of proof to justify their actions when defending a FOIA petition, so it's important to include a thorough factual background and to be specific about the reasons that a records request was denied or whatever the issue is in the petition. It's better to provide more information that is needed than not enough. If there's anything that's extraneous, it would just be disregarded. On another point, parties are encouraged to submit affidavits. If there's someone with relevant knowledge about the issue, and especially if a FOIA coordinator has been instrumental in preparing a response to a FOIA request and had searched the records, it would be helpful to provide an affidavit from that person who actually did the search and can attest to what occurred. It's a very quick process, so email is our preferred method of communication. Once in a while, we will still get petitions and communications through mail and through fax. We accept those communications, but of course we encourage everybody to use email as much as possible to keep it moving. Another thing to keep in mind is that our opinions will only address issues related to the FOIA statute. It's fairly common to see a petition that includes allegations of violations of other statutes. But as we had pointed out in the earlier slide, that's something that our office cannot consider. Also, just keep in mind that the DOJ itself is a public entity that's a public body that's subject to FOIA, and the procedures state that the petition and the response will be provided to a party who requests them from the DOJ under FOIA. So it's important to be aware that the response and the petition could both be released as public documents as well. And finally, I do want to point out that this may be somewhat rare, but if the parties are able to reach a resolution of the issues, that they are able to do that, are able to communicate while a petition is pending. And if they do resolve the issue, we just ask that they provide us with written notice that the petition's withdrawn. So that wraps up our discussion of the petition process. Our next speaker is Deputy Attorney General Lisa Morris, and she'll be discussing open meetings and executive sessions.
Hey, good afternoon, everyone. I'm going to speak briefly on open meetings and executive sessions. Some of you may or may not deal with your boards that were within your agencies, and so I'll give a brief overview. So an open meeting is any meeting that occurs of a public body. Public body is defined within the FOIA statute. It can include a formal or informal meeting. So within our guidelines that are available on the DOJ's webpage, you will see certain questions and answers as a breakfast meeting, an informal meeting, can it be a public meeting? Those are answered in those guidelines. The meeting can take place either in person or by video conferencing. A common question about video conferencing is where that can occur. That has to occur in a place that's open to the public and that was noticed to the public that it would be occurring there so that they can attend and everyone can see and hear the other parties. You are required to provide notice of a public meeting 7 days before the meeting occurs and to maintain minutes of all meeting. There are exceptions to those to the rule of 7 days, and those may or may not apply depending on the situation. So you can consult your DAG for your agency. On the notice, it must include the time, date, and place of the meeting, and then also whether or not you'll be using video conferencing. If there are multiple locations for the meeting, because you are using video conferencing, you will list all of those locations on the notice. The agenda must list all of the discussion topics that will be looked at the meeting, and then must also include a reference to the executive session if you plan to have one. So the executive session would refer to a specific category, and we'll go through some of the available categories. You cannot use a catch-all, so you cannot say we may or may not go into executive session and not give a reason. We want to see a reason there. So in order to call an executive session, once you're in the meeting, you would convene an open meeting. You do need a quorum present to open the meeting and begin. You would take a motion to enter the executive session and provide the reason. It could be the reason that you've listed in the agenda to go into executive session. During the executive session, minutes should be taken. They should be kept separate from the minutes that you're taking in the otherwise open portion of the meeting. And you want to limit the discussion within the executive session to only the purpose for which you are in executive session. So if the discussion starts to go on to other topics, you can end that executive session and go back into a public meeting. Most importantly, there is no voting in executive session. So to the extent that action needs to be taken following the discussion that you had in executive session, that action must be taken in an open meeting. So you would end your executive session, you would return to an open meeting, you would invite the public back in to the extent that they're still there, and then you would take any action or any votes once you're back in a public meeting. The reasons for executive session are limited. Most frequently, we might see an executive session for the discussion of a citizen's qualifications for a job. We might also see student disciplinary cases or personnel matters that have to occur before a public body. To the extent that you have a question about whether a topic that you would like to discuss or one of your public bodies would like to discuss and whether that qualifies as a reason for an executive session, you want to seek out the advice of your DAG for your agency, let them know what you think the discussion is going to look like, and they can let you know if there is a reason for an executive session. Other reasons include strategy sessions with your attorney, to the extent you're discussing potential or pending litigation or collective bargaining. And so there is a limitation. It can't just be that you're seeking legal advice on a general issue. There is also an exception or a carve-out for discussion of non-public documents. So as we know, when you have a public meeting, the discussion is open to the public. The documents that are circulated become public documents and FOIA-able. If you have non-public documents that need to be discussed, you can use an executive session for that purpose. Who can attend an executive session is a question that we receive often. And most generally, we say the parties that can attend an executive session are the voting members of that public body. In addition, we contemplate that the DAG for that board can also sit in on that executive session. If there is staff that is integral or needed in order to keep the meeting going, they can sit in. And then anyone else, any member of the public would be asked to leave. You can invite in a subject matter expert to the extent that one is needed. That person can talk to the public body, provide the board the information that they need to receive in order to facilitate their discussion. And then once that person's role or need has been satisfied, they can leave and the board can continue their discussion. So we do not invite non-members to stay in executive session merely as observers. Okay. All right, so that is it on executive sessions. I am going to turn it over to DAG Kitty Mikowski and Jameson Tweedy. They are going to moderate the FOIA coordinator panel.
Thank you to all the panelists who are willing to participate. 3 returning champions, let's say, and one new challenger. And also thank you to Kitty Mikowski, who's helping me with this. So our panelists, and I'll let them just give a quick background on their role and their experience with FOIA before we dive into the panel discussion. But starting immediately here is Lee Sobosinski, who's the FOIA coordinator for DENREC. And if you could just give a little bit of background on your role in FOIA and your experience.
Sure. I've been with DENREC for about a year and a half. We started a process where to centralize the FOIA process in DENREC, and that became effective July 1 of 2018. I believe we received the most requests for the state. And prior to that, I was with the DOJ and was a paralegal for DENREC and helped with reviewing FOIA requests or responses.
Hi, I'm Chip Guy. I'm with Sussex County Government. I have been with Sussex County since 2005, so I guess I've been there 14 years. Prior to that, I was in journalism, and I was tasked with the dubious distinction of being the FOIA coordinator, I believe, in 11 or 12. So as the joke goes in my organization, there's no one else here who can do it. So I'm not an attorney. I just play one when it comes to FOIA. So that's my story.
Good afternoon. I'm C.R. McLeod. I'm the Director of Community Relations for DelDOT. I previously have served as a FOIA coordinator during my role with the Delaware Department of State as well. So all told, about 6 years I've been in this wonderful world of FOIA that we all have come to know and love. Currently, just to give you a sense of how much activity we see on a regular basis, I think we run pretty close with DENREC. As of this morning, we've processed or are processing a total of 317 FOIAs year to date. If my math is right, that'll put us on probably roughly about 365 for total for this year. So, which would be just a little bit higher than we did last year. So we do see a lot of FOIAs come through the Department of Transportation. I have a great team of paralegals. We have a great deputy AG on our staff as well to help us manage all the requests that come in. I would say with my duties, I'm also the public information officer for the department, and ultimately end up probably spending probably roughly about 10 to anywhere from between 10 to 15% of my time working on FOIAs on a weekly basis.
I'm Dan Shortridge. I'm the Public Information Officer and FOIA Coordinator for the Sussex Technical School District. I've been working in FOIA for about the last 5 or 6 years, first for the Department of Agriculture, then for the State Housing Authority, and for about the last year and change for Sussex Tech. Before that, I worked in journalism, had a close familiarity with FOIA from that perspective. I filed my first federal FOIA request when I was a college journalist, so I've been working with this stuff for quite a while. It's a lot of fun, I think, but it can also be a lot of challenging, and I think as you'll hear today, sometimes we do have a tendency to make it more complicated than it needs to be. So looking forward to the discussions in this panel.
So we're going to dive right in to some of the do's and don'ts and kind of give you, allow our panelists to give you some guidance on how they on a day-to-day basis deal with some of these issues. So the first topic we're going to talk about is actually once you get the FOIA, what the heck do you do with it? So you need to get your agency and the proper people involved in gathering documents or records that are responsive. So I'm going to turn it over to Lee and Chip to talk about, how do you guys get your staff or custodian to buy into this whole their FOIA obligations and getting this done? Obviously, your analyst or your department personnel have other things that they are responsible for. So how do you get their attention on FOIA?
It actually happened pretty easily. Like I said, we were consolidating and bringing it under the Office of the Secretary. So we had all of these FOIA coordinators throughout the division and or the department. So they were very happy to no longer be the contact point with the public. So we got great buy-in very quickly. We still do have a few that want to do it the old way, but it doesn't take long to get them back on track.
And for my organization, and let me back up because I didn't provide enough background on my situation. I'm also the communications director and handle PR for Sussex County. So FOIA probably eats up 10 to 20% of my week, but it can ebb and flow depending on what's coming in. And I average anywhere from 150 to 200 FOIAs in a year's time, and I think that's a lot for a county government. And so with that perspective, as far as the buy-in and getting your organization to understand the importance of FOIA, I mean, the reality simply is you have to do it. What we do as government agencies, be it at the local level, the county level, or the state level, the simple fact of the matter is we are obligated under the law to comply with the law. And I try to convey to staff that I share in their frustration. I understand that it can be burdensome, that you have to stop what you're doing to handle something that you may see as being trivial or as time-consuming and really not worth the time and effort. But it's important to that constituent. And, most of my coordinators understand, and the way we're set up, it is a central intake system. I'm it. So if you make a FOIA request, it's coming to me. Morning, noon, night, I don't care if I'm on vacation, I'm sick, I'm in traction, I've been indicted, it's coming to me. And my organization knows this. But I do have coordinators set up in each of the individual offices, so I've kind of structured it kind of like state agencies. I mean, I've got planning and zoning here, I've got engineering here, and so I have a point person in each of those departments. And that person is someone that I then rely on to feed back information to me, to convey to me whether there's going to be staff time involved, if this is something that is easily obtainable or attainable, and I work with them, and that's how we have our system set up. Ultimately, for Sussex County, the way I view FOIA and my leadership view FOIA is that this is really about providing good customer service, and that's something that we pride ourselves on. I have adapted my procedures to give departmental coordinators a minimum 5-day window to respond to me on any requests that come in. And these are the ones that are more voluminous. If it's something that's easy and they can turn it around in 15 minutes, give it to me. But if it's something that's going to be a little more of an endeavor, I've tried to institute that to show to them that I understand that they have other demands, they have other needs, they have other priorities. FOIA at the moment may not necessarily be theirs, so I give them a 5-day grace period to get their affairs in order and then get back to me if it's warranted. So that's my take on at least getting some buy-in from my cohorts and coworkers.
So Chip, let's stay with you. Do you ever have an instance where there's lack of responsiveness? So it sounds like you have a dedicated, internal policy where you give them the 5 days. Do you then follow up with them? How do you get them to respond to you?
Generally, I don't have issues with responsiveness because I rule with an iron fist. And they know that Chip will just badger them to no end. So your mileage may vary. I don't know. Each organization is different. But I really don't have that being an issue. Maybe early on when we established this. Mm-hmm. But now everyone kind of knows the rules of the road. They know what they have to do. And yeah, I mean, I joke about it, but the reality is if you don't come to me within the 5-day, I'm not breathing down their neck right now on, hour one, mm-hmm. But if I haven't heard from them within 4 days, I might just, ping them with a message to say, hey, where do we stand on that FOIA?
Right.
If you get to 5 days and no one ever truly does, then then I may have a conversation with you and or the supervisor. But generally, the staff is very good about keeping me informed and staying on top of it as time permits.
And what about you, Lee? How do you deal with responsiveness or lack of responsiveness?
Fortunately, like Chip, our divisions are very responsive. There are a few on occasion, they were out, no one knew they were out, and I just follow up with with them, with the division designee, and then also with the director. There have been times when I have had to go involve the deputy secretary just to push them along, remind them how important it is. But for the most part, I get responses very, very quickly, or at least a response to say, we're working on it. It's probably going to take us X, Y, Z, or something to that effect. But fortunately, we are responsive.
And one thing I'd like to add, I mean, really, staff just needs to understand that a lack of responsiveness on their part, and then that, balloons up to the organization. It not only reflects just poorly on them as individuals, but it reflects poorly on the organization as a whole, and it can set you up for a violation. And ultimately, that's your job to make sure that that does not happen. Right. So that's one of the things you do need to convey to them. And like Lee said, I think most of them get it.
Okay. And Dan and CR, how do you deal with media requests or it sounds like a couple of you are PIOs anyway. So how do you deal with handling media requests?
Sure. I guess let's get kind of a quick show of hands first to start with. Can everyone who's a FOIA coordinator put your hand up? Okay. And everyone who has your hand up, so keep it up. If you're also a public information officer, put your hand down. Okay, all right. I think we had a reversal on this last year. Yeah. So this is aimed at folks who are FOIA coordinators, but not also PIOs. Or if you're involved in that pipeline somehow, that is get to know your PIO. They can save you from a lot of pain and a lot of difficulty later on. As best practice, your PIO should always be looped on any controversial or non-routine request. You don't want to have your PIO blindsided by something, especially if it's a request that involves a member of the media or a touchy problem subject, controversial topic. You always want to make sure that they're looped in there, in part because they also see and know things that can identify patterns that may be helpful to you and to your agency's leadership.
And I'll just respond on that and also cross over back to what Chip and Lee were also just mentioning. We've made it clear that, again, there is an expectation that we have to fulfill FOIA. Everyone is busy, but these are making sure folks are educated appropriately on how to respond to FOIA and the whole process. What I like to say is, we get enough bad press. We don't need any more because we didn't fulfill our obligation in responding. And we have our log, and we pride ourselves on. We get very voluminous requests in our department, and we do our best to make sure that we are documenting every step of the way to ensure that we are meeting that criteria and being as responsible as possible.
So, wanted to shift into something that was raised a little bit in the presentation earlier, and that's the somewhat dual role that FOIA coordinators play. So, as we've mentioned in the presentation before, one of the roles of the FOIA coordinator is to be the facilitator between the requester and the agency, to be the point person that allows requesting parties to get what it is they want. On the other hand, the FOIA coordinator also has to be the person for the agency that is looking at the exceptions, understanding FOIA, and knowing when requests are proper or improper. So I was hoping maybe we'll start with Chip and then Dan, if you could comment on sort of that dual role and how you treat that interaction between the requesting party, especially if a requesting party is doing something that is not quite the typical request that you would just fulfill.
In terms of communicating for clarity's sake,
yeah,
on the specifics of a request, typically what I have done as far as communicating with the party, it is a balance. I mean, you're there to work in the interest and serve your organization, but you are serving the public and you're serving the constituency. But in some instances, it tends to be rare in my experience. I think most of the time that the FOIAs that come in are fairly obvious and simple to accommodate, but you do get the occasional one that is a little more nuanced, or it's not as clear on what it is they're looking for, and you have to sort of wend your way through that. I find that it's best to communicate with people I know this is a foreign concept in 2019, face-to-face or one-on-one or verbally, rather than doing things through email or letters, because that has a tendency to sometimes not be as clear, and then defenses get employed, and they're upset, and it's just easier a lot of times to just simply pick up the phone and have a conversation with someone and say, what is it you're looking for, and how specific, try to get that out of them. But I've had to on some occasions go the route of written communication, but like I said, I just think it works best to have that verbal interaction. A lot of times the public just does not understand FOIA, and they don't understand the process, more to the point, and they think it's I like to say kind of a magical genie in a bottle. They just say, give me this, and then this torrent of information just comes magically down the pipe. And it just doesn't work that way. Emails are a perfect example, and I've discussed this with Dan. The best analogy I have is it's like walking onto the bridge of the Starship Enterprise and saying, computer, give me all emails pertaining to such and such, and there it is. It just does not work that way. And that's why you have to work with people to try to get some terms that are applicable. And I think in most instances, people then, once they're familiarized with the process and FOIA, are willing to work with you. I do have, I've had a couple of occasions where someone just absolutely did not want to provide search terms for email. So I had to infer the terms. I had to make my best guess, good faith, guess on what those terms would be. But I forewarned them. This may or may not be a complete record, because this is what I could come up with. These are the individuals I thought might be party to the conversation, and these are the topics and terms that I thought might best call the servers to identify records that are responsive. So I guess that's a long-winded answer, but
it's perfect. Dan, do you have anything to add sort of on that, communicating with the requesting party, making sure that there's clarity and understanding both ways?
Yeah, I think clarity is the perfect word to use. When I get a request in, I want to have as much clarity as possible. I want to understand almost as if I were in the requester's head as to what they're looking for. If that involves picking up the phone and asking them, sending a couple emails back, that you have to do that, because in large part because when I go to my records custodians, they're going to ask me, well, do they mean X? Do they mean Y? Do they mean Z? Do they mean 1? Do they mean 2? Do they mean 3? There's a lot of detail and a lot of nuance in the records that we have. And so if I can get that clarity up front, that saves me work, it saves my staff work, and it makes things just a lot smoother for everybody involved there. So it may mean a little bit of back and forth up front. But I agree with Chip completely. I think a lot of the general public does not understand how we keep records. They don't understand the records that we have. And so the simpler we can make it for them, the simpler we can break it down at the outset, the easier it's going to be on everybody.
Thanks. And so that sort of is directed towards the facilitation angle of the FOIA coordinator's role. And then the flip side is having to know what the rules of FOIA are and being able to enforce them. So I was wondering if maybe Dan first and then Lee could chime in on the way in which you work with legal counsel to sort of understand and apply the parameters and the appropriate exceptions to FOIA.
Yeah. So my best advice when you're working with your legal counsel, talk to them first of all when you're just starting out in the role. If you're brand new, you want to have a sit down with your attorney to go over some processes, how they like things, their special expertise in FOIA. You want to talk to them when there's an issue of first impression for you, whether that's a certain type of record, a certain exemption that you haven't dealt with before. When I was at the Housing Authority, all of a sudden I had to deal with some specific exemptions in federal law that still covered some of these things. So that was all new for me. I had to talk to our attorney about that. You want to talk to your attorney when there's a denial or redactions. That's really important. And then honestly, occasionally when you just need an extra set of eyes or something to bounce something off of, that's where your attorney can come in very, very handy. That's a lot easier if you're a state agency and you have a DAG and they don't charge by the hour. If you have an outside attorney, like I do currently working at a school district, things are maybe a little more complicated. You want to be very clear with your agency's leadership and financial staff about when you're going to contact them, when you're allowed to contact them, what types of questions you're going to contact them for, so you don't inadvertently run up a nice bill there. Don't be afraid to ask questions. Keep them concise, and you may have to do some education if there's an outside attorney involved, because exactly what your agency does and why and how it does it may not be crystal clear in all the little nuances that they do. You may also have to have some conversations about some recent FOIA rulings. If there have been opinions or case law that have recently come down, you may have to be the one that educates your attorney if they don't practice in this area a lot. So that's my advice for that.
Thanks. Lee, anything to add on the relationship with legal?
I have a really good relationship, probably because I used to work with all of them. But I basically send a request for anything that could possibly be denied, and let them know, explain what the situation is, give them the background, and then go with whatever the decision is, probably back and forth, and even as mundane and simple as an out-of-state request. I will not deny anything without the approval from one of my DAGs.
So, and both Dan and Lee, you started to touch on it, but getting into denials, I was wondering if you could each sort of talk about, any best practices you have in terms of when to issue a denial. Well, obviously that's covered a bit by the statute, and how to go about the process of issuing a denial, and then also a sense of just how often you might actually issue a denial.
I try to, especially if it's pretty clear on the front end, it's out of state, or it's not a valid FOIA request, or it's not, if I can tell that up front, then, within a day or so of getting it, I will go out, reach out to my DAGs, draft a little memo, send it in an email, and then wait for the response back. Sometimes it's not until after we've sent it out to the divisions, and they say, oh, wait a minute, this is under investigation, this is in litigation, and then I will, so it may be a little later in the process, but usually it can somehow I'll know about it, and especially if it comes from an attorney's office, it's probably likely there's some litigation involved or potential litigation. But again, like I said, I will not deny anything without, even if it's a routine one or it's one that we just recently had, I'll still send it back out. I'll still send it back out to the attorney and just say, here's another one. Yes, you can deny it, so that if it does come up on a petition, then I have that record.
Do you have a sense of what percentage of total requests you might end up denying?
I would say probably maybe 10% at most,
Mm-hmm.
And most of them are for out of state.
Dan, do you want to jump in on that?
Sure. So your mileage is really going to vary on denials. There's no clear-cut thing, because it really differs from agency to agency. I've worked for agencies and for public bodies that have not been heavily into the regulatory side. If you are a regulatory agency, you may have a lot more to deny based on the investigatory file exemption, just as one example there. So you're really certainly going to vary there. The requests that I've worked with, I would say about 90 to 95% have been produced in whole or in part. So at around 5 to 10% denial rate there, and that's just a rough estimate. Very few are denied outright in my experience. And those that are denied are typically very clear cut. They involve a personnel issue, or the investigatory file exemption, or it's something covered by federal law. There's not a whole lot of nuance there necessarily. As far as issuing the denial itself, you really want to keep things as cordial and as simple as possible. The requester is going to get frustrated because they're getting a denial letter. You don't want to make ratchet that tension up at all. Don't make it too formal. Don't, no offense to the attorneys in the room, don't write it like you're an attorney. Write it like a person-to-person business letter. Respond in the method that they requested. If they send an email, reply in an email. No, there's no reason in my point of view, there's no reason to write up a letter on letterhead and attach it as a PDF. Just do it in the manner that they requested. And keep the language simple. You may want to have a couple citations to explain some things or some hyperlinks, but keep it as simple and plain language as possible.
Thanks.
So we're going to turn now to the importance of FOIA logs. You've heard earlier about the requirement to keep FOIA logs. So we're going to turn it over to Dan and Lee to talk about their best practices in maintaining their FOIA logs. When they're how do you regularly update them, and how much detail do you include?
Ours is updated throughout the day. As soon as a response as soon as a request is received, it's logged. It's and any information that is available in the request is updated in there, who it was sent to, and so that's kind of real time. Once the response is sent, then it is updated with that. Or if there's a denial, or if there's a has to go to DTI. Whatever the steps are within the process until it's actually resolved. Our FOIA log has much more detail than is required in the statute, and one of the reasons for that is because we receive a lot of requests on properties. So that way we can determine, we've already received a request for this property. Is it a duplicate, or is this a different company that's requesting the information? So then you have a quick snapshot, and you can hopefully cut out the duplicates. If you can catch them a lot easier that way. But then it's also, you can just go back and look for it if you've received a similar request. Hey, have I received this request? Oh, here's the same thing. Who did I send it to? What did I do? Instead of having to search back through your files and everything like that. So we have a lot of information on our FOIA log. And like I said, it's updated real time, basically.
How about you?
Yeah, I would totally agree with Lee. I always err on the side of more detail. I use an Excel spreadsheet to track. If you're an executive branch agency, there's one that's mandated for you to use. I recreated that when I came over to the school district. But I have a notes column where I describe what was provided, what was redacted, anything that's a little bit different about that request. I always copy and paste the actual text of the request rather than try to summarize it, just so I have that to go back to at a moment's notice. When you have really, really complicated, challenging requests, or ones that you think may end up in the appeals or petition process, it may be helpful to keep a day-by-day timeline separate from the log that explains what you did when, especially if you think it's going to come down to an issue of a time extension. That can be very helpful, especially if you need to explain why time has passed, or why you needed additional time to go into archives and get these records and that sort of a thing.
Thanks. We're going to jump over to fees, but before we do that, CR or Chip, do you have anything you want to add on? We sort of have stuck with Lee and Dan for a little bit.
Well, I would just add that the log, it's also important to remember that we frequently get asked for at least twice a year for a copy of our log. So
right.
Keeping it updated and as detailed as possible without making it something that is a hindrance is really important. Again, and I know we've discussed this previously, but whether you're looking at it every day or you're setting time aside to look at it a couple of times a week, knowing that that's going to be a public document, and again, it's a reflection of your agency, so making sure that it's ready to be presentable, really at short notice.
Yeah.
I concur with everything that. Well, for the most part, everything that's been said. I tend to take a little more of a happy medium approach to the log itself. I don't go into excruciating detail on every request, because I have digital copies of every request that comes in. From my perspective, the log, which is like Dan, I use the Excel spreadsheet, and it's 18 or 19 fields. For me, my view is that's more of an index, an accounting of what has come in, what's transpired, on what dates. It's a reference tool. But then I have every request that's come in, digitally archived. I have all the documentation as far as any communications that have gone back and forth among staff. So that's been my approach historically.
Thanks. So there was a part of the presentation earlier that dealt with fees. We wanted to talk a little bit more about sort of the practical approach to fees and how the agencies handle it. So maybe start with Lee and then Dan. How does your agency handle fees, requiring fees up front, providing estimates? How do you collect payment? That sort of thing.
We send the request out, and then the divisions will determine if it is going to need time more than an hour, and then they will respond to me and say, this is going to take 3 hours to accomplish, and it's going to be an admin 3 who will be processing the request. So then I will draft the cost estimate and send it out to the requester and let them know that we will not proceed without until we receive their payment, and provide all of the information on process or how to send the payment back in, and also ask them to respond if they accept the if they are interested in still receiving the documents, so that we know kind of where we stand. We just recently started an online payment portal. So we've processed 2 payments through that so far. So it's really easy, and because checks, someone would send a check and it would get routed throughout the state until it finally wound up on my desk like 2 months later. So obviously this is a much quicker process, and it's much cleaner.
So fees they're not designed to be a profit center, as I think Joe said earlier. But one of the fundamental principles with FOIA is that the requester bears the cost and not the taxpayer. So I always try to put on my good steward hat when working with this process. That said, coming up with estimates in particular can be really, really tough, especially if you're dealing with a lot of paper data, paper records, a lot of stuff that's in archives. Joe mentioned you can't charge for legal review, and as a practical matter for me as the FOIA coordinator, that means you get almost all of my time for free, because you can't really practically separate the time that I spend going through documents or going through records to review for responsiveness from legal review. Because when I go through there and I say, okay, this is a yes, this is a no, this is a yes, this is a no, I'm also flagging things for our attorney who will conduct the actual legal review. So you can't really separate those two. So it's practical matter. You get all my time for free. That's one area where the law may diverge a little bit from what's realistic there. I agree with Lee. Get complete payment ahead of time. I haven't experienced this, but I've heard from other public bodies that have had checks bounce. You don't want that to happen to you after you've sent out the records, because you're not getting that money back. If it does rise to the level of requiring fees, you do want to be a good steward of taxpayer dollars.
I'd like to add, not to throw anybody from the Fourth Estate under the bus, but I was a former member of the Jedi Order. It was a member of the media who bounced one of my checks. So, and what I've done since then, if that party makes a request, I make sure the check clears before the documents are granted. So I try to get payment within the 15-day period. You make the payment, and then once I know the check is cleared from my accounting folks, then you'll get your documents.
So Lee, you mentioned having set up an online portal for payment. CR, I think DelDOT has a similar process.
Yeah, absolutely. Just in the past year, we had worked with DTI to develop an online system. What we were finding, majority of the requests we were getting, again, I mentioned earlier, are pretty voluminous and oftentimes require many hours of work and require some form of payment. And willing parties to pay and saying, okay, can I give you a card number? Can I, and we were saying, oh, well, you have to mail it in. Again, it just wasn't really good government. Mm-hmm. In today's day and age, we have the technology. So we have a system that is working extremely well now. I would say we're processing probably 90% of our payments electronically now. It cuts down on the time. We're not the requester is not waiting that additional time for, as Lee said, for the payment to navigate the state government bureaucracy. It really, I think, cuts down on just the paperwork and the time to process these things. So we've been very happy with it. For the other agencies and your employer, I think it's definitely worth looking into. I think now that some agencies have already done it, I think it should hopefully be easier to apply to your specific agency. So I would definitely encourage having that conversation. It makes life a lot easier when you get that ask for a payment. So we continue to look at ways across the board at how we can automate and streamline to make this process. It can be a very time-consuming process, as we all know. So any way that we can incorporate technology to make it a little bit easier, a little bit faster in getting the information processed is a win.
Absolutely. So one of the things that goes hand in hand with the fees is how large, how voluminous, how broad a request might be. Chip, I was hoping you could talk on just how to go about trying to work with a requester if their request is going to generate a fee estimate that is not what they're going to be willing to pay for the information.
And overall narrowing the scope.
Yeah.
Right. And to dovetail with something that Dan said earlier, and this is my philosophy, I think FOIA is just more difficult than it needs to be most of the time. And a lot of that is because, again, the public does not understand what it is, when it should be used, how it should be utilized, and that we're back to give me everything, and it just magically appears. It doesn't work that way. I like to say that too often I think FOIA is used as a hammer when a scalpel will do. And that's why it's critical to try to get some clarity and get that specificity that you need in order to reduce staff time, thereby cost to the requesting party. And in most cases, when I've had these voluminous requests come in, or these catch-all requests that it runs the gamut, and I communicate this with the requesting party, most of them understand, okay, all right, well, really what I'm looking for is this, but I thought this was the best way to approach it, was to go and tell you I want X, Y, Z when I really want Y. And so, generally speaking, people are understanding that the more broadly stated that it is could translate into more cost for them. And as soon as they understand that they're on the hook potentially for hundreds of dollars, you'll get them down to a more finite request. One of the things that I wanted to touch on here, as far as well, okay, that's the next one. I think we'll come back to that. Well, do you want me to segue into that?
Yeah, sure.
Yeah, sure.
And we've talked about this a little bit before we had the panel discussion. I think, again, I'm back to, I think too often people utilize FOIA. It's what I call the weaponization of FOIA. In my organization, I am dealing with 130 requests so far this year, so I'm probably on pace for about 150 when all is said and done. 2/3 of those requests could have been satisfied with a simple phone call, checking our website, or whether in the wrong place in the first place. 2/3. 2/3 of the requests that have come into me that I've had to stop what I'm doing to deal with were in the wrong place, or they could have been dealt with if they had just gone to the website. They would have found the budget there. They would have found the CAFR document there. They would have found minutes from a meeting. I don't think that's what FOIA is for. FOIA is not for us to be your taxpayer-funded research monkey. And too often I get this, particularly from firms that are utilizing FOIA for commercial purposes, to data mine, to glean information so that they can turn a profit for a client or for themselves, what have you. And I push back a little bit. That's probably not it's probably not the right thing to say here, but I push back a little bit in terms of educating these parties. This is what FOIA is for. You can satisfy this request by simply going to this link here on our website. And in many instances, once I've educated the party, sorry, Denrec, but I push a lot of them to you because they come to us thinking that we're the environmental. Well, we have a division called Environmental Services, and Environmental Services is our wastewater treatment plants. That nomenclature, though, confuses people, and so they see that and they think, the county has an environmental agency. A lot of times it's because I'm getting out-of-state requests. So I will respond back to them to say, no, the county is not an environmental authority. Everything you've asked for here is all in the purview of either DENREC or the State Fire Marshal's office. And most of the time, I get these engineering firms in particular, once I've educated them, they understand that, they won't come back and ask again. But then I have some of the perennials and the frequent flyers who insist upon having documentation that you don't have anything. And to that I say, I mean, do you go to the town of Fenwick Island to ask for something that you know clearly they don't have? I mean, why would you ask for me to produce, which, by the way, my creating a response constitutes creation of a document, which FOIA says I don't have to do. I mean, there's a circular logic there that just doesn't make any sense. I don't have anything. I'm not a responsive, agency, and yet you've made a request of me insisting that I provide documentation to say that I have nothing, and I have to actually go against the grain of the law that says I don't have to create a document in order to satisfy the request because I've got to respond to the request. If you can follow that, good luck.
Thank you. So, any advice, Lee or Chip or anyone else, on how you actually prepare the cost estimate? Joe sort of walked through some of the pieces that need to be there, but any sort of practical hands-on steps to prepare that cost estimate?
I have a kind of a template that it says it has the title of the person, and then their hourly rate, and then the number of hours, and then the final the final amount. If there are multiple people that are involved in the process, then I will include all of them, list them out. Usually the divisions will send me the information of who's involved. I don't provide names, but just the titles and their salary. At one point the comment was made, well, people are concerned about their salary being out in the world. Well, it was just, in the newspaper a few weeks ago or so. So that's really not a concern. I guess the concern more would be, I make this and you make that and now I'm that, but that's irrelevant to FOIA. So I just send it out. I have been asked, I don't provide an affidavit at that time, but have been asked for an affidavit for in a petition. So, just to attest to the fact that these are legitimate costs. These are the folks that are needing to do it, because sometimes it's not just at an admin level. It's, the director is going to review the documents. So we say that we have taken every measure we can to have the lowest paid individual involved, but these are the people that actually have to provide the documents, provide and review the documents.
Thanks. Chip or anyone else?
As far as cost estimates for my organization, if I have a request, and it's rare that I have a request that I will see that will exceed the 1 hour. Most of the requests that I deal with can be accommodated in less than an hour. But I will notify my finance division that if I see something that I think will exceed, and all of my coordinators in the various departments know to communicate to me if they have time that they think will exceed, really 15 minutes to a half hour on their end individually, because cumulatively, if you've got 2 or 3 departments that have to pull information and each one of them's got 20 minutes in, well, now you're at an hour among 3 coordinators. But in any event, if I see something that I think is going to warrant a lot of time and attention, I will put the finance division on notice. And I have a central, and we'll talk about this more coming up later in the discussion, but I have a central intake system for all of my FOIA requests. I have a portal online. And whether they file it through the portal or they send it in, snail mail or an email, I move everything in that portal because then it allows me to centralize and ticket everything. And as part of that system, we have integrated into it our fee schedule. So for all the copies and what have you, but the administrative time, that's why I need the finance division, because it depends on the department, depends on which coordinator, or which staff member has to pull the documents. Once I've identified those individuals, they in finance will set up a spreadsheet for me and send me an accounting of those titles, those staff members. It won't be by name, it'll be by title, that are tagged on the request and that are the lowest paid, who can accommodate and who can satisfy the request. I will provide that along with a written response on letterhead that says your total estimate is this, and as an attachment they can then see the accounting. So that's my process.
Perfect. Any other thoughts on fees or best practices or anything else before we shift topics?
I'd just say take the time. As it was alluded to earlier, there have been more challenges. I know this because we are often dealing with big requests that get big dollars associated to them to fulfill. When it goes to the AG's office, it's going to, doing the homework in the beginning and making sure you're laying out, how you arrived at that number is going to make it a much easier for everyone, going forward than having to try and backtrack and explain it. So take the time. That would be my best advice.
Yep. Okay.
So moving on, Sierra, let's stick with you for a second. Chip talked a little bit earlier about identifying custodians and with the various divisions that you have. In your agency, which is fairly large, do you have determined people who you're going to reach out to as far as identifying custodians for a particular request that you receive?
We do. We have a very big agency, and it's also spread out across the entire state. So sometimes, depending on what information is being requested, it's not someone who's just down the hall from you. So we do have a much like Chip alluded to, point persons in each division where really we become gophers. Okay, how do we uncover this information and obviously do it in a fairly tight turnaround. So making sure that we have that matrix. And again, you do see turnover, so making sure as one person retires or takes a new opportunity that you are working with the director of that specific division to have a point person there that is going to be your go-to person in helping track this information down is critical, because you can easily run out the clock looking around trying to figure out, okay, who does this go to? So really time is of the essence, and having those persons there that are responsive, understand, and are understand the process and are able to really be hound dogs and stay on their staff to get this information is a critical component.
And what about you, Dan? How do you identify the appropriate custodians for a request?
Sure, I'll take the small agency perspective. I haven't worked for anything as nearly as large as DENREC or DELDOT, but as a practical matter, it comes down to knowing your agency and building relationships. If you know the people in your agency, if you know the type of work they do, that'll make things a lot easier. That said, you will be constantly surprised by what your agency does. I worked for the Department of Agriculture for 5 years, and I learned something new just about every week. You mean we have something to do with emus? Okay, that's interesting.
Who knew?
One technique that I used was to be a presence at our division head meetings. I did a half-hour training overview of FOIA for our division directors, explaining what it was, the obligations we had, how it worked, and as a practical matter, what I would do when we got a request for them. And that really helped smooth things a lot when it came time to building those relationships. Above all, you want to make friends with your administrative assistants, because they will make or break your handling of a FOIA request when it comes down to it.
I think that's good advice, just to build off of what Dan's mentioned there. And earlier he had asked how many in here were not just the FOIA coordinator for their organization, but also the spokesperson. I think if you're on the communications at the PR end of things, you gravitate toward this anyway. You're usually in the know, or you're vaguely familiar with a lot of different things within your organization. But if you are among those individuals who are simply the FOIA coordinator, you may not necessarily be in a position where you're in the loop on a lot of things. And to Dan's point, you need to be as familiar with what's going on, the inner workings of your organization, as much as you possibly can, so that when those FOIA requests come in, you know how to route them, where to route them, and who you need to speak with.
Great. We're now going to switch over to sort of the nitty-gritty of handling requests and collecting documents. And Chip, you alluded to this a minute ago, but maybe we'll start with you on the software you use to manage the process.
Right. I don't know how widely used this is in the state. I know a couple of agencies have looked at it, but I use something called GovQA. It is an online document portal management system for intake of FOIA. It's actually developed by a company out of Illinois called WebQA, but their product is called GovQA, and it centralizes the process, at least online. It's a portal that we have integrated into our website, where the requesting parties can set up an account, make a request, and then they can track their request, and they can also see their past requests. So they can also go back to a request that they made. Perhaps they've lost a document that they requested before, and they can visit that through their portal or through their account on the portal. And that just helps me on my end to have everything centralized and all in one place. I do keep outside of that digital copies of all of my requests, so that if something ever happened to it, I have a backup of my own. But it really does help me to keep it organized. And I mentioned this before, if I get a request that's written and comes in by mail, very rarely get a fax anymore. I mean, does anyone still use fax in 2019? I will get emails that are outside the portal. I will push those into the portal, create a ticket, and then manage it through that. It is a little pricey, especially if you're a smaller organization. That product, I think, runs me now about $9,000 a year. And there was some setup costs to do that. There is another product out there called Just FOIA, and it's by a company, I think, out of Florida called MCCI. So if you're interested in either one of those are two that I know that are out there. And like I said, it provides a centralized system for accepting, managing, tracking requests. I have my coordinators in each of the departments. They have credentialed access to manage their respective departments and duty assignments when they come in, so they can't cross-pollinate. They can't go over and deal with somebody else's ticket or another department's assignment. They can only deal with those requests that they're tagged on. It's an easy-to-use interface on website for the public. Allows users, like I said, to view their past requests. And like I said, if you're probably a larger organization, that's something you might want to look at. It may help you to clean it up, keep it consistent, and keep it all in one place.
Thanks. Maybe Dan and then Lee, can you talk about the process your agencies use to actually collect the documents, sort of the mechanics of that process?
Sure. Again, I'll represent the smaller agency perspective. It's a little more informal with us. I get a request. I send it to the person or people that I think handle that. I usually copy it to their director or supervisor. Staff sends the records back to me. If they exist in hard copy, I get a physical file. I scan them. I hand them back to them. There's not a huge process or checklist. The general approach that I take, though, is to play dumb a lot. And one thing that I do to make sure, do my due diligence, make sure that I've got everything I possibly can, is to sit down with the custodians, both before and after I get the records, and to walk me through the process. A lot of times, staff that deal in the minutiae of a particular program or particular area, they may overlook things, not due to any malice, not due to wanting to hide anything, but just because they don't think of things in that way. The example would be if somebody requests all records, that's a great term, about incident X, and you ask the staff for their records, and they hand you this one-page summary report that they produce about it, and they say, that's what we've got. You say, okay, well, they asked for all records, so what about the emails? What about the handwritten meeting notes? What about the voicemail files? Were there any of those in there? So you have to kind of go through your checklist and make sure you've touched on all those things. And having that conversation with your program staff, with your subject matter experts, and asking them to walk you through the process of what they do when they handle an incident like that can be very helpful in making sure you've covered all your bases there. You have to ask a lot of questions, and again, it goes back to those building those positive relationships there really, really helps.
Lee?
There probably about 75% of our requests are very routine requests for documents regarding a property or things like that. So those are I send it out, and I get the documents back pretty quickly because it's usually in a database, or they'll say no documents available for that request. So those are the easy ones, but then we do occasionally have some more involved ones, and usually if it's something of that nature, then I will meet with the team who will be processing the request. We talk about it, and actually the funny thing about the all records, this one that I have going on right now, they were more concerned about the all records than I was. So they kept saying, so does all records, that would also mean this and mean this? And I said, well, yes, it does. So they were more in tune to that than I was expecting. So, but usually everything comes back via email, or if it doesn't, then I will get the records, like you said, if it's physical records. I will get them. Sometimes they will offer to scan them. We are in the process of getting everything available electronically. So more and more things are available electronic. So that's nice. And then of course, if anything comes back from DTI, then we have to process it through their process.
Dan or Lee, if you could talk a little bit about hard copy documents, and especially things that may be archived or harder to locate and get to.
So hard copy documents are not that much different than electronic documents. Most times you're dealing with electronic documents, but you just make a copy, scan them, make sure you have them in electronic format once you have them to turn over, because people are probably going to want them sent in electronic format. For archive documents, you really want to know your records retention schedule. If your agency is required to keep a certain type of record for 3 years, then you need to have those on hand. Make sure you're sticking to that, and that's a little bit outside the range of the FOIA coordinator's bailiwick, but it's something really important. If you're concerned about the image of your agency, you want to make sure that you have those there. I do want to put a plug in. Who's here from the Department of State or Public Archives? Okay, excellent. The folks with the Delaware Public Archives are some amazing but very unheralded state employees. Get to know them, make them your best friend, take them out for a cup of coffee, have them explain how their processes work, go over your records retention schedule. They can really help you in a tough request, or one where you really have to go back into the archives. Thanks.
You started touching on this, Dan, a little bit, as sort of the difference between hard copy and electronic documents, and your thought was not so much difference nowadays. I wondered if maybe you could start, and then CR, if you could chime in on best practices for email queries, searches, working with DTI, that sort of electronic search effort.
Sure. So is anyone from DTI here, first of all? Okay, all right. I just want to get a sense of who's out there.
Yeah, you can badmouth that will.
But it is being recorded.
In all fairness to DTI, they get a lot dumped on them. A lot of times we don't understand exactly what they do or why they do it. I'll just say, in my experience, when you have an email request, speaking from the state agency perspective, it's a little bit different if you're a municipality or a local government or some other public body. You need to make sure that you do that local search first. And make sure that you're checking locally stored emails. So you know how when you're in Outlook and the little message pops up, do you want to archive these emails? Do you want to auto-archive these emails? If you get that message and you click yes, my understanding, my experience having dealt with this, is that those emails will be locally archived on your computer. They may not turn up when DTI does a search. Okay, I've been burned by that before because we didn't realize the difference. Asking DTI to do a global search will not capture those locally stored emails, so that's why it's really important to go through and try to do that local search first, work with your in-house staff, and then if you need to go broader, then go to DTI. They're not automatically searched by Outlook's normal search functions either, so we have to go into each individual archive file and pull this out individually.
if either Dan or CR, if you want to offer any thoughts on how you go about, or anyone else, how you go about constructing those search terms, or how you may work with DTI or other agencies to sort of help you craft those electronic searches.
Yeah, definitely getting back to one of the points earlier in this conversation, getting as specific as possible. We often will get queried for, emails over the last year containing the word crash. Well, in the Department of Transportation, I would, maybe two out of five, every emails could have that term in some form or another, and getting thousands of hits, and then you've got this, you're putting together a ridiculous assessment for what that would take to put that type of record together. So, drilling down as much as you can to find out, okay, what are they really trying to get here? How can I help answer this without costing a fortune, and also taking up a massive amount of employee time? So, drilling down and then identifying all the parties that you need to, that would be have information that you need to get to, and making sure, again, checking the box that they're going through their, not only checking their local inbox, but their archived inbox. Do all that first before having to go out to DTI. Because again, DTI is going to assess a fee for that. So doing as much as you can with, internally working with the employees that would be subjected to having information related to the request, and getting, just really trying to minimize the scope, to ensure that it's not going to be something that's a massive burden for both the agency and the requester.
Yeah.
It's funny that CR should mention, the word crash, because context is key. My computer crashed.
Yeah.
You send a message to, your IT person, that email's going to come up.
Right.
I had a case in the last year, 18 months, and I won't mention the name, but the proper noun, or the proper noun, was also a word that can be a verb. And so every instance of that word coming up, which it was presented to us as the name, it was also coming up in emails where it was being used as a common verb. So I had to, separate the wheat from the chaff, and it's frustrating. One other important point to make when it comes to establishing search terms, you actually, this is going to sound counterintuitive, but you actually have to think wrong. And what I mean by that is, you have to sort of sometimes insert misspellings and typos into your parameters, because that's the way it may have come in. And if you type in, I only want this word or these words, and if the system doesn't see anything that matches that, it'll kick it out. I don't know, the best analogy I can come up with is seafood for seafood. So you type the word seafood as part of your search parameters, but you really want seafood, and you're just putting in that variable to see if anything comes up that may have been, responsive, but someone included a typo.
Yeah.
I'll chime in there. Another key part when you're doing email searches is just setting the universe of accounts that are going to be searched. A lot of people think that, as Chip says, the Starship Enterprise analogy, you can just hit a button and you're searching everybody's email. That's not how DTI does searches. They have to have a list of accounts. So that can be, especially if you're dealing with a contentious request, that can be one of the most difficult things to try to narrow down with the requester, is exactly whose inboxes do you want to have searched during this. So that goes back to that negotiation, that liaison with the requester. That's really important. Make sure you have that honed down, and that they understand that those are the only inboxes that are going to be searched.
And to build off of that, a lot of times the party has no idea who the parties who may be party to the discussion are. So you have to kind of do some inference on your part, some best guess as well. All right, I know of an organization of 500 people that 490 aren't going to have a conversation or have been a party to this conversation. There is a little bit of guesswork on your part. You're making a best guess, good faith estimate. It's not to say that there isn't someone that you didn't anticipate who may not have been part of your search. So you probably should try to be as more liberally inclusive in when conducting the search, So, maybe a department director for my planning and zoning office, I definitely would have her searched, but I may have a couple of planners in that office or inspectors who might have been, touched in an email discussion, just to make sure that I'm not leaving anybody out.
One last topic on the document collection side before we move on to the next thing, and that is the nuances of producing information from databases. And I think, Dan, you might be able to chime in on that.
Yeah, this is one that gave me a lot of headaches a couple years ago. If you get a request for a database, let me backtrack a little bit actually. I want to give a shout out to DTI and GIC, Government Information Center, the Department of Technology and Information, who've done a phenomenal job with the state's open data portal. They have taken a lot of these databases and data sets that have existed just on local computers and put them out there for anybody to see and slice and dice and play with and download. I know there's some resistance to some of those things, but overall, putting on my member of the public hat, it is absolutely phenomenal and makes life easier for so many people. That said, if you get a request for a database that's not part of that open data portal, or it's not something that you have on your website, as Chip mentioned, you really need to have some very clear conversations with the requester about what they're going to get. And that's why knowing your agency and its records and its functions is so important. The story I'll tell goes back a couple years to a journalist who wanted a spreadsheet, an Excel spreadsheet, exported from a proprietary database that we used for some of our enforcement actions. We did it, but the database, once exported to Excel, was completely incomprehensible. Even our staff, we sat down with the reporters and they couldn't interpret it because it was not meant to be used in that way. It was meant to be used within the database. If they wanted to buy a copy of the database software, they'd shell out $10,000, but nobody wants to do that. And that's not really fair either. So we weren't trying to hide anything, but the requester's expectation conflicted with our very, very stark reality there. A lot of times when people want a database, what they're referring to is just an Excel spreadsheet. They'll want a data dictionary that explains what every item means. And the reality is that a lot of our agencies in government use highly specialized databases that's very specific to their line of work and not easily exported. So you really want to make sure that everyone is on the same page going into that process. Those requests require a lot of work, and if you're clear up front with what they're going to get out of it, that'll save you a lot of headaches at the end.
So we're going to turn now, we have a couple more sections before we open it up for Q&A, but the next section is really, has to deal with redactions, confidential information, confidential documents, and the mechanics of redacting and determining what's confidential and what's not. So Lee, I'll turn to you first. It's, for DENREC, do you have a situation where you have, if there's a sense of maintaining confidentiality or third-party confidential information?
Yes, we do have a process in place if a third party or vendor, whoever it may be, wants a document to be held confidential, they have to submit the document to the Office of the Secretary with their requested confidential redactions, and then it's reviewed. Usually legal gets involved, and then they determine yes or no, we will accept all, we will accept none, we'll accept some, and then that's a process that they go through, and once the document is considered confidential, that is marked as confidential, not to be publicly released, and then the public document, the public version, is marked as public, and then can be released for a FOIA request, or if they're going to put it on a website somewhere.
Great. Dan, how about you? How do you deal with confidential information or redactions?
Sure. Just purely from the logistics side of it, my practice is there are two people who should be doing any actual redactions, and that's the FOIA coordinator or the attorney. The reason for that is you're dealing with confidential material. A lot of it very non-public, some of it may be very personal. If you're dealing with a lot of documents in a standard format that have the exact same thing on every page that needs to be redacted, like a social security number on an application, you may be able to delegate that, but anything else that requires a high degree of sensitivity or subject knowledge or responsibility, I'm making sure my eyes are on that and I'm the one responsible for that. I've had to review documents that had the social security number and the personal credit card number of my cabinet official, so I'm not delegating that for anybody else. I use a non-standard redaction practice. We all know black magic markers don't work. We've all seen how electronic redactions can be reversed by people just clicking a button. So I scan a document as a PDF. I redact it in Acrobat using their redaction software, print a new document, and then scan the printed redacted file. That is going to frustrate a lot of my journalist friends who want to be able to easily read something or use OCR to do it. But I'm not taking any chances when it comes to redacting a lot of personal and confidential information. When I'm sending an electronic file like an Excel spreadsheet, sometimes I'll copy and paste the cells into an entirely new file, just to make sure that nothing gets carried over that was redacted or hidden in that previous version there. I don't want anything to go out from my agency that has anything sensitive or exempt on there.
Thanks. And Lee, you talked a little bit about instances where vendors or third parties want to keep information confidential. Do you often have an after call with them? So in other words, if you get information in that may not have been submitted as confidential, but a FOIA request comes in and you're concerned that some of the information that was provided was confidential, or do you have any situations like that? Or how do you deal with vendors when they're requesting confidential sensitivity to their documents?
That has to go through the Office of the Secretary. We have had situations where, especially for bids, there was a request or it was deemed confidential. The document was deemed confidential, and we will go back out to the party and explain that we've received a FOIA request, and your document is really not confidential, and sometimes maybe certain pieces are, but we let them know that we've received the request and then that it will not be considered confidential unless they can provide a valid reason for it to be considered confidential.
So it's open communication that you have with your particular vendor or the third party. You
Yes.
give them a call and you say, we got a FOIA request. You've deemed the entire document confidential.
Right. Usually it's the someone within the division who had prior experience with them. If there's an issue that arises, then I will get involved, or the Office of the Secretary or legal. But usually they'll just shoot an email. We got this FOIA request. We're going to produce this document. If you don't let us know within 10 days or whatever the situation actually is, and then they will say it's not a problem, or we really would like this part of it kept confidential, and then we go through that process of whether it can actually be considered confidential based on the rules of confidentiality.
Okay. And Dan, you touched a little bit on the best practices for redactions and using Adobe Pro and scanning PDFs, and you also talked about who's appropriate to make those redactions. Does anybody else at any of the agencies have that experience? Like, what are your practices for redactions? What are your practices for who should be making the redactions? CR, you want to chime in?
We do limit the redactions to either our DAG, myself, or our senior legal paralegal, just in terms of judgment and experience, and then also making sure that we're validating it. So we'll have before we send something out the door, we'll sit down and look at, okay, what's being redacted, and this is why, because it's directly attributed to this exemption, and we go through each one. It can be a little tedious, especially when it's a large document, or a document with a lot of a request with a lot of documents associated with it. But again, it's doing our due diligence to ensure that if it's questioned in any way, that we are on solid footing in terms of why that was applied.
Chip, how about you? Do you have any process for redactions that you?
Similar to what's been articulated here by the others. It's very limited to whose eyes have clearance for seeing the material, and that's generally restricted to either the legal team or myself. Obviously, my leadership, my county administrator, for instance, he may be a party to it. But as far as the mechanics of reviewing the documentation, implementing the redactions, that's handled by either legal or through me.
Okay. It sounds like we have some good best practices, but I think we have one more section to go over.
One more quick section, then we'll go to the question and answer, which is FOIA coordinator's role in open meetings. And so we'll sort of just do this as a broader topic, but if everyone could comment on do you have involvement in open meetings for your agency? And if so, what aspects, and do you have any recommendations for the FOIA coordinator's role in open meetings? Maybe start at the end, Dan, and
sure.
Run on over.
So I had a kind of a little bit of a paradigm shift, moving from an executive branch agency to a local government. I work for a school board now. So it went from an agency which had, a quarterly pesticide advisory committee meeting, which nobody was really interested in, to local school boards, which lots of people are very interested in. So that was an interesting experience. And it was a bit of a challenge because I'm not in the executive sessions. I don't want to be in the executive sessions. I'm not setting the agendas. But if we do get a complaint, a lot of times the FOIA coordinator is pulled in that regard there and does have to give some advice and perspective. The advice I would give, if you're involved in that, be part of the conversation, be aware of what's going on. And just because that's the way it's always been done doesn't mean that's the way it should be done. I'll just, as a reporter, you see a lot of things that happen just because public bodies kind of slip into it as general practice over the years. Look at how other similar public bodies prepare their agendas and that sort of a thing, and ask lots of questions if you're involved in those types of things.
One thing I'd just like to add in terms of open meetings that can be overlooked, that we try to pay specific attention to, and it's a little bit outside of FOIA, but it's also ADA compliance. That's something that we're looking at when we do meetings across the state. So we're, sometimes we're in schools or we're in fire halls. Really, we can have a meeting, in a communities. Some communities have a small building that you're able to, but making sure that we are ADA compliant is something that we've had to reschedule meetings for. Hey, we're going to do the meeting here. We've got everything ready to go. But there's only steps getting into this building. That's we need to make sure that it's accessible and that reasonable accommodations can be made. That's what the language in the ADA states. So that's something that we're also paying particular attention to, and as opposed, not just making sure we're posting the meeting and publicizing it in all of the ways that are required, but making sure that the facility that you've chosen is accessible.
That's a great point. Chip, do you have any?
Second, what Dan and CR have said. In my organization, I too, as the FOIA coordinator, I'm not charged with, or the communications director, I'm not charged with drafting the weekly agenda for the county council, but I'm part of that conversation. At some point, usually on a Tuesday when we're drafting the next week's agenda, I may go to the clerk of the council just to peruse over it very quickly. I have counseled the clerk and the county administrator before sometimes on the way something might need to be presented on the agenda, or we may need more specificity because this is too broad a topic. I am aware of the 7-day rule, and that's important if you're part of a body that has or part of an organization that does have some body that meets. You need to make sure that you're compliant with the law and having your agendas posted not 7 business days but 7 days. 7 days is 7 days is 7 days. So just understanding what the law requires. It's important that you try to be a part of the conversation if you can be, as far as the meetings and agendas. And I'm also fortunate. I don't attend executive sessions either, and nor do I want to. But I am part of the open sessions, and I'm there for media too, and constituent relations and things like that. So it gives me a good sense of what's going on and where we are on the field.
Thanks. And Lee, do you have any role in the open meeting, any of the open meeting process?
I do not. I
Perfect.
think I need to have a discussion, though.
Well, thanks to you all. Really appreciate your time and your thoughts. We'll now go to a question and answer session, and just as a clarification, we definitely cannot offer any legal advice. That is not what this training is for. So please don't ask those questions, or Carla will intercept them if they are.
I will, but if you have questions for any of the presenters, we will answer them also.
Do you all ever handle a situation where a request is made and you can't work it out, it's voluminous, and an offer is made to have the requester just come in and inspect documents? And then a subset question of that is, what if you do that after providing an estimate that's high, and they agree to come in and inspect documents instead of paying, and they start photocopying the documents with the camera?
Joe, let's.
I suggest that be a topic for next year. I've not had, in my experience, I've not had an instance where, I mean, most of the time, I can tell you in 7 years of doing this, I've maybe had 1 or 2 instances where someone wanted to come in and look at copies. It's just not the way people operate. They don't even really want to go through the pain of making the request. I mean, but they'll do it. They want everything sent to them electronically. That's just the way it is. I don't know how to answer the question because I haven't encountered it. And is it worth thinking about? Perhaps. I mean, the ubiquitous nature of cell phone technology, and that anyone can take a photo of anything at any time. I would suggest that if there is an instance where you are dealing with someone who wants to review a file, you do not let them sit by themselves in a room. You have it in as secure a room as you can possibly have, and you monitor the activity as far as the review is concerned to ensure that they're not taking away information that they weren't going to pay for. And certainly you should not go into a review with material that is confidential in the file. It shouldn't be in there. You need to go through the file beforehand to make sure anything that should be privileged or withheld is not subject to their review.
Actually, we do have a number of times where the requester comes in and reviews files, and we've had either situations where the file is all together. The person who is in charge of the file will go through it and make sure whatever's confidential, attorney-client privilege, whatever is removed from it. She sits with them as they go through the file. They usually bring a scanner, scan whatever they want, and off they go. We did have one where it was a pretty big request, and in order to gather the documents and get them together for someone to review, we did send out a cost estimate. They paid, and then they came in and reviewed and made copies or scanned as they were going along. So we have had those types of situations where, and sometimes we'll offer for them, we'll say it will cost you $50 to scan it, or you can come in and look at it, whatever their choice is. So.
Yeah, and that's important to note, though. I did think about that myself. If you did have an instance where they wanted to review, there may still be administrative time involved to get them to that point. So I don't think if someone's looking at this as a way to short circuit and bypass, saving on the cost, it may not necessarily work to their favor. In fact, it might wind up, entailing more work to give them or to organize it in such a way so that they can come in and review it. But I don't think that, if someone wants to sit there and take snapshots on their phone of publicly accessible documents to avoid the photocopying fees, I don't see that there's really any grounds or reason that you would have to deny it. If they want to sit there and transcribe the whole thing slowly, they could do that too. It's quicker for them just to take a snapshot and to avoid paying $9 in copying fees. I wouldn't have a problem with it. Is my point.
So I was one of those requesters once that came in and did that back during my reporting days. It was involved an agency that sounds a lot like Del Dot. And it was a very simple and painless process. They made it easy for me. I went in, I sat down at a cubicle area with a paralegal who was there to monitor and make sure I didn't steal any engineering plans. It was a very, very, very painless process. I don't, as far as the hypothetical about snapping photos, it's as Chip said, it's the same as copying something down by hand. There's really no reason for us, in my opinion, to charge a fee for something we don't do. The whole idea is that you get, your ink and your toner, your paper costs back. You recoup that somehow. But if taxpayers aren't paying that cost, there's really no basis for us to charge them. So if they want to sit there and snap 100 documents with their phone, more power to them.
Right.
I wondered if anyone on the panel could give an example of the redactions that you're doing. Kind of, when I think about the documents we're providing, they should be public. So if you're redacting stuff, what can't the public see? And or would they fall under some of the
Exemptions.
Freedom of Information Act exemptions? I don't know if you could give an example.
One of the biggest ones is personal identifying information. If it's name, phone number, address of a citizen, that would be redacted out. We also have like public wells, that information is redacted. And then there's like if it could be used to cause a terroristic attack, something like that would be what we have redacted out in the past.
Also at the top of the list, and don't make this mistake, legislator emails.
Yep. Yes.
Yeah, you won't make that mistake twice. They are exempt per the law, and
And that extends to you and to your organization. I mean, I've had the instance where, or the circumstance where, as a county government, we may have emails that came from the legislature or their staff. We've had to go and remove their emails because they're protected under the law. Someone may think, well, I can't go to the legislature and ask for these emails. I'll go around them and I'll get it from a subordinate agency or I'll get it somewhere else. The onus is on you to ensure that those emails are protected. And as far as your question is concerned, I just did some redactions this morning for executive session minutes. And pending or potential litigation, land acquisition, personnel issues, nope, can't have it.
Well, again, those are all things that they shouldn't be getting those documents. So, why would you redact anything?
Because in the case of my executive sessions, there are a multitude of items that are discussed that are all permissible under the law. Some of those items may still be ongoing, and thus they're permitted to be redacted.
Oh, so you took them out of the minutes?
Well, they're just redacted. So there's a block of black there, and then the next subject matter is a matter that's been adjudicated. So I can't deny, I guess your question is, why wouldn't you just simply deny the whole document?
Right.
Because portions of the document are in play and subject to FOIA, so I have to disclose them.
That makes sense.
One example from time with the Housing Authority, under federal law, the names or other identifying information of recipients of federal housing assistance for people who live in public housing or receive housing choice vouchers are exempt. We had a request for a database of all of our public housing recipients. We said, okay, we'll give that to you, but we're removing all the names. We're assigning each one a unique identification number that exists only for the purpose of this FOIA request, so that you can match rows up to rows and things like that. And they said, that's fine, that's what we want. So we did that and stripped that out there. So the rest of the records in that database were perfectly fine to release. We just couldn't associate it with specific names.
Okay.
Other questions? You touched on this. Can you talk just a little bit about the agency does not have to create reports if they don't exist, or create documents? As a school district, we've had to deal with this several times. Stan's probably had to deal with it. Can you just address that a little bit?
It's an ever-evolving issue. I don't know that there's ever going to be, a final determination on it, but we are encountering that, it seems, here with a little more frequency, because what happens is you'll have parties that want something specific. They want the records a certain way. Statute and case law says you do not have to create a record, and you do not have to create a record to necessarily, match with what the party is asking for. If you have a document that contains the information that they're looking for, I'm not going to ask for legal advice, but it's my practice and in counsel with my legal staff, we will give them the document if it's a discoverable, FOIAble document. We'll give them that document that contains the information that they're looking for, but we don't have to create a document that's customized to satisfy their specific needs, and then we'll say, this is what we have. That's the record, because that's what FOIA guarantees, access to the records that exist. Not that we start, tailoring records, and because then you're no longer providing access. You're basically satisfying custom queries. And again, I said this earlier. This is not what FOIA is for. It's not what FOIA is for. And it's my experience that too often now, FOIA is being utilized by individuals who, I had a request one time. They wanted every dog license issued in the county back when the counties had dog licensing, and the reason why they wanted it was so that they could turn around and have those mailing addresses to send mailers for pet products. Now, I don't think that was what the legislature's intent was, but I didn't have a say in the matter. It was a public document. I had to provide it. But don't think that is, I don't think that's where the public understands, I don't think most of the citizenry would appreciate that their information is being gleaned for marketing. But I'm powerless to stop it. If it's a public document, I was advised, I think in that instance, that it was public, I had to give it up. But as far as giving, information or tailoring a report to satisfy every aspect of a request, if you don't have that document, but you have a document that contains some of the information, or you have a couple of documents that contain information, let them do the work. Let them blend, the fields from this Excel with this Excel and this Excel, and, more power to you. Anything you want to add?
I'll say one area that I've observed that happens a lot, and it has to do with spending. A lot of times people will want specific details on how much you spend on X, Y, and Z, and that information may exist in 10 different printouts from your financial system. It's as Chip said, you don't have to create a record. There have been times where, in the interest of good constituent relations, if it is not going to take me very long, I'll go through, pull those printouts out, throw them into a spreadsheet so that they have it all in one place and don't have to sit there and try to puzzle out what do these different things mean there. Sometimes I will do that. Sometimes it's simply not possible to do that or not practical to do that. But that is an approach that I've taken on occasion.
And I agree with your sentiment about good customer relations. But at the same time, it's a balance. Particularly if you're one coordinator for an organization, which I am, and there are other hats that I wear, it's, if you want this information, this is what I have that's easily available. FOIA guarantees access. It's not that we're there to do the work for you. And trust me, I don't know what everyone else's experience in this room is, but I am seeing it on a continual basis, and it's growing. And I get a lot of out-of-state requests, and I know the law allows you to deny based on those grounds. My philosophy there, and this is what's at play in Sussex County, is I don't deny on those grounds, because I view it from the standpoint, if I've got somebody who owns a second home in Sussex County and they want to know about a sewer project that's affecting their property, but they give me a Northern Virginia address when they make the request, how am I to know what their interest in Sussex County is? I think, to me, they've got a very compelling and legitimate interest in knowing, what's going on. I have no way of knowing, whether if they supply a Delaware address, I have no way of knowing whether that's a second address, whether it's a fictitious address, whether they're doing it by proxy. I don't have a mechanism to verify everybody who makes a request, whether they're a bona fide Delaware resident. I don't require a license. I don't require 2 bills. You could really go off the deep end as far as trying to verify residency, and I just don't have time for it. So, in that regard, I think I'm far more permissive and far more liberal in my interpretation of the law and accommodating the public. But on the flip side of it, I don't think I am there or we are there to craft reports and put the records together so that they understand it. I'm not saying you're obstructing. You just give them the records that you have. This is the record. This is where it's contained. And if they want to work with that and do with it as they wish, that's on the party who's made the request. I don't think it's on us as taxpayer-funded agents.
I think there was a question over here.
Chip, you touched on it a couple of times. Those people that have weaponized, and I'm thinking individuals, have you or anybody else at the table, has anybody developed a solution or a way to manage those? I'm thinking specifically individuals, not necessarily media outlets, that may send one or two a week.
Frequent flyers.
Frequent flyers. Yes.
I have one in particular, and I don't. Oh, I know. Of course not. I have one in particular, and as far as that party is concerned, I don't find the requests to be onerous. They're regular. Could this party simply make a request to the clerk of the council and get what he or she wants? Absolutely. But this party has elected to go a certain route, so I accommodate. And if that's the way this party wants to do it, then, I mean, I don't really know that there is an answer. I don't have an elixir to solve that or stem that issue. I have had instances where I've had parties who I felt were using the FOIA process to try to, probably carefully choose my words here, parties who were trying to sort of put us on notice that they were watching, and if you want to come in and look at the planning and zoning file, I have no problem with that, and you don't need to file a FOIA request for it. Come in and take a look at the file. It's publicly available, 8:30 to 4:30, Monday through Friday, and we put a lot of this stuff online. I didn't get into this too much in my talking points, but education, I think, is critical in a lot of this. It's just explaining to people, what FOIA is there for. I view FOIA as the process, the portal and the mechanism being there really for the more onerous stuff. The simple one-offs, I want a copy of a building permit. They're coming at us a lot of times because that's what they know in other jurisdictions. You want a Kleenex in XY jurisdiction, you got to file a FOIA request. And I don't subscribe to that philosophy. You want a copy of the permit? Well, we have permits on our portal. Go and view it there. I mean, I want to save you time just as much as I want to save staff time and money, because it's costing staff and the taxpayers money to accommodate a request that otherwise, if they had walked in off the street and walked up to the permit counter, they would have got a copy of the permit right there and never executed FOIA in the first place. Which, by the way, they are executing FOIA, just not on paper. It's a FOIA-able document. It's publicly available. You coming in and asking for it at the counter, you're actually exercising your right under FOIA. The statute affords you that. We don't make them fill out a piece of paper to do that. But as far as what I say is the weaponization, I have had a couple of instances where people are using it, I think, because they've got an agenda. They're trying to make a point. I know there was a case in one of the beach towns a couple of years ago, if I'm not mistaken, where there was actually a coordinated effort to overrun the community with FOIA requests. So it is out there. In the other respect, as far as, it's not necessarily weaponization, but it is certainly utilizing FOIA. If you're a third party and you're gleaning for information and you can get it by way of going through FOIA, it's not so much weaponization, but it's utilizing the law. They know you have to respond. They know you have to accommodate. And that's where I, again, try to educate people that, hey, okay, this time I can give you this information, but in the future, if you want this, we have it available online by going to this portal here, and I will provide those links in my responses. I also, one other point I want to make, in my software tool that I utilize, we have something the vendor has incorporated in it called deflection. So if they start to type environmental records, a pop-up will come up and say, whoa, stop right there. Sussex County doesn't have environmental records. We are not an environmental agency. They start to type court case. Sorry, courts, state of Delaware function. I like that a lot. I like to say state.
Thanks.
Sorry. But it's the reality. I mean, we're very different in Delaware. The structure of government here is alien to a lot of out-of-state people, even people in state. People who have no clue where anything is. They just know government. So that's a very handy tool in my software that I can't tell you how many that prevents. In fact, that's one of the questions I asked my vendor in the last 7 to 10 days. We were having a discussion about, enhancements and what have you. I don't know how many cases or requests have been avoided simply based off of deflection. But if there are ways that you can, maybe it's as simple as putting some information on your website. My town or my agency does not have this information. That's about the most you can do. You can't stop them from still making the request.
I have a comment to that. We've had someone who, frequent flyer, contentious, knew her stuff, but, had an agenda basically. And our deputy secretary actually took it upon herself to contact this person and discuss things and, opened up a line of communication so that I haven't seen a request from that person in quite some time. So that's a one-off, but it really has helped. And again, it kind of goes back to finding out what they really want. And, some people think we're hiding things, we're not going to produce this stuff, whatever. And this was a way to kind of take this person out of the FOIA system and be able to work together to try to, accomplish what they were looking for.
That's an important point that I'd like to just finish up with. Getting them out of the FOIA process a lot of times, you just don't need to be there. You could have simply accommodated this if you had just sent me a phone, or if you'd sent me an email or made a phone call and said, hey, can I get a copy of the building permits for last year? No problem. I'll zap it right to you. I don't need the documentation. I know some agencies, they want to document everything. They want to dot every I and cross every T. I could be overrun with documenting every request that comes into my organization in a day's time for the simple stuff. If you can get them out of the process, my advice is to have that conversation. I had a firm that was making requests of me on a regular basis, knowing full well that my organization did not have the information that they were requesting. And I called them to say, why do you keep doing this? Well, I need to have documentation in my file for my client. I sympathize, but that's kind of not really my problem. I mean, you're making a request of me and you know full well that we don't have it. So I played a little bit of hardball, and on the last request I said, this is going to represent the final request the final response from this organization on these requests, because you have been put on notice verbally and in writing that we are not this agency. We have no governance over this issue, and yet you continue to come at us and insist that we create a document. Your responding is creating a document. FOIA says I don't have to create a document, but yet I got to do a response to satisfy my obligation under the law. So it's this conflict there. So my approach was, I had a conversation that didn't work. They continued to come at me. I finally just said, this is it. This is the last response. I've told you we don't have it, and you're wasting our time and you're wasting your time by making the request to the organization when I've pointed you in the right direction.
So thank you for the panelists. Unless we have anything else, thank you for everyone coming and watching this.